Mr. Atkins? Mr. Atkins? Oh, you?
Yeah.
Okay, your attorney had you log on, state that you could not be here today for your exam?
No.
Sorry, I can't hear you.
Wrong person.
Your lawyer said that you were going to log on to address why you could not be here today for your exam at 2 o'clock.
Yeah, I was sick last night, and this morning I woke up throwing up. I was actually on my way to the doctor's right now.
Okay, so I will give your attorney a new date and he'll let you know what that date is, okay?
All right, thank you. I appreciate it.
You're welcome. Bye. Mr. Jennings, you should be in 332.
Thank you, ma'am. My apologies.
Oh, you're fine. It's a mix up with the courtroom.
Okay, thank you, ma'am.
Well.
Ready.
Mandarino? Yeah. Mr. Jennings, you have to log off and log in at 332.
Okay, sorry about that, ma'am.
Okay, this is case 2359300. The people of the state of Michigan versus Darnell Adario Dykus with defendant number 1, Martise Anthony Parker with defendant number 2, Lavinia Spivey Jr. with defendant number 3, all charged with, actually not all charged, defendant 1 charged with count 1, weapons carrying concealed, count 2, weapons carrying concealed, defendants 2 and 3 are charged with. Set for an exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor, Madam Clerk, Madam Court Reporter, Jonathan Roberts, P86428 on behalf of Mr. Dykus. Mr. Dykus, could you please state your name for the court?
Sorry, no, Dykus. Good afternoon, Your Honor. Sean Godwin, P74500 for Mr. Parker, who's standing in the courtroom before you today. Mr. Parker, please state your name.
Martise Parker.
Good afternoon.
And good afternoon, Maria Manarino, P39531, on behalf of Mr. Spivey, who is present in the courtroom. Mr. Spivey, can you identify yourself, please?
Okay, good afternoon, sir. Is everyone ready to proceed?
The people are,
Defense is ready on Dykus, Your Honor.
Press is ready on Parker. We'd ask for a mutual order of sequestration.
And ready to proceed, join in the motion.
Okay, for anyone who is watching on YouTube or on Zoom, who may be a witness in this case, now is your time to log off. And for the record, in the courtroom, there are no additional parties except for attorneys and Mr. Dykus, Parker, Spivey, and staff. Will there be an OIC present throughout this? Okay.
this time I don't believe so.
And if you need him to come or her come in, just address that with the court. Anything else?
Nothing.
Nothing from defense, Your Honor.
Nothing else.
You call your first witness.
At this time, the people call Officer Michael Flannel.
Yes.
The door's right in the front. So make sure you speak up in the mic. Whenever you're ready, Mr. Kirk.
Good afternoon. Could you please restate your name for the record?
Michael Flannel?
And are you currently employed?
Yes.
Where are you currently employed?
Detroit Police Department,
And in what capacity?
law enforcement officer.
And how long have you been employed as a police officer?
Little over 3 years.
Were you employed as a police officer on January 22nd, 2023?
Yes.
Did you in fact work on that date?
Yes.
Were you by yourself or with a partner?
With the partner,
And what is your partner's name?
Officer Perry,
And were you in full or modified uniform?
full
Were you on foot patrol or in a scout car?
scout car,
Is it a fully marked or semi-marked scout car?
fully marked.
And did your duties as a police officer take you to an area at or near 19331 West 7 Mile Road?
Yes.
Is that in the city of Detroit, county of Wayne?
Yes, it is.
And did your duties as a police officer also take you to an area at or near 19193 Huntington Road?
Yes.
Is that also in the city of Detroit, county of Wayne?
Yes.
And let's go back to that first location at West 7 Mile Road. What brought you to that area?
It's a green light location conducting a special attention.
And when you say green light area, what do you mean by that?
It's overlooked by Detroit Police.
And when you say conducting special attention, what do you mean by that?
I just go in there and make sure no one is lower green or sticking around a place that's not supposed to be there.
And did you observe anything while you were conducting this special attention?
Yes.
And what was that?
There's a vendor with a bulge on his right side. I noticed him, noticed the scout car. He didn't open up.
And when you say offender, is there anybody in the courtroom present today that you're referring to?
Yes.
Could you please point out that individual and identify an article of clothing that they're wearing?
Black shirt, blue mask.
Could you point them out?
Black shirt, blue mask.
And maybe where on the bench they're sitting?
Far left.
Your Honor, let the record reflect the identification of defendant number 1. And can you go back to your observations regarding defendant number 1?
I observed him with a bulge on his right side. I seen him look at the scout car. At that time, he opened the front right passenger door to attempt to hide his right side.
Objection, Your Honor, to speculation as to what he attempted to do.
Response.
Specifying to what he observed.
I would just ask that he can speak to the movements, he can't speak to the intent.
I would agree. You can officers should speak to the way in which words, but as far as what you're trying to do, only you.
I seen him open the front right passenger door and blade his right side away from him.
And when you say blade, what do you mean by that?
He turned his right side to where I couldn't see it.
And what did you do after noticing his movements?
At that time, I asked him, was he a CP holder? He stated yes. I didn't answer the scout car. I asked him again, was he a CP holder? He stated no.
And why did you ask him a second time?
He had a youthful appearance.
And why was the youthful appearance significant?
Because you have to be 21 years of age to have a CPO.
And after he said he did not have a CPO, what did you do?
Performed a pat down to his right side, revealing that he did have a firearm on his right side.
And how did that reveal that he had a firearm on his right side?
We had to lift up his shirt.
And can you describe what you saw, or actually, can you describe what you felt during the pat down?
Heavy metal object.
And why is a heavy metal object significant?
It's similar to a firearm.
And can you describe what you saw on defendant number 1?
Firearm halfway in his waistband.
And what did you do after observing this firearm?
The firearm was then recovered and placed in the scout car. I asked how old he was, and he stated 19. And who recovered the firearm? Officer Perry.
Did Did you observe Officer Perry recover the firearm?
Yes,
Yes, what color was the firearm?
I believe it was black.
And what was the size of the firearm?
That I'm not too sure on.
Was it a larger gun? Was it a smaller gun?
So I believe it was a full size.
And what did you observe after recovering the firearm?
I observed, Mr. Spivey, get into an unknown vehicle on the front right passenger side, where I'm issued on a ticket for, smoking marijuana. in the other area.
Can you speak up just a little bit? I think I won't play, but.
At that time, I tried to issue a ticket for Mr. Spivey, but he had already left the location.
And when you say Mr. Spivey, is there anybody in the courtroom today that you also came into contact with on that date?
Yes,
Could you point out that individual and identify an article of clothing they're wearing?
black t-shirt, blue pants, far right side.
Your Honor, let the record reflect the identification of defendant number 3. And you said you were trying to give him a ticket,
Yes,
and that was for,
smoking marijuana in public way.
and you observed him smoking marijuana?
Yes,
When did you observe him?
when we put into the parking lot of the location.
And how did you know that it was marijuana?
I can see it and I can smell it.
Can you describe what you saw?
A brown marijuana cigarette.
And you said before you could give him a ticket. Why were you unsuccessful in getting number 3 a ticket?
He had got into the vehicle and pulled off the location.
And can you describe that vehicle?
My reply was to keep our report, yes.
Were you reviewing a report, that's your recollection?
Yes,
Your Honor, may I approach?
Yes.
You recall the vehicle?
yes.
Describe the vehicle.
2013 Chrysler 200.
And did you observe this vehicle leave the location?
Yes.
How did it leave the location?
It left going northbound on 100.
And what did you do after the vehicle left?
I lied my partner and I stopped the vehicle.
Was the traffic stop conducted?
Yes.
And why was the traffic stop conducted?
Well, one, I had to issue my ticket for Mr. Spivey, and the vehicle was also parked left the curb with no insurance.
You said the vehicle had no insurance?
No.
Objection, Your Honor. Lack of foundation as to whether or not the car has insurance. Just ask Dave to clarify exactly how the car doesn't have insurance.
I ran the vehicle per lane. The dude did not have insurance. He was also issued a ticket with no insurance.
Record, do you want record that?
I was going to ask that question. I didn't ask it. I'll answer again. For the record. And how did you determine that the vehicle had no insurance?
Lane,
And at this time, Your Honor, I would object to best evidence and hearsay. My knowledge, neither myself or co-counsel were provided a copy of the lien. I know that there is, I think, in the prosecutor's office, a policy that says that lien cannot be disclosed to defense counsel. I would point Your Honor to MCL 28.214, which specifically says that prosecuting attorney in a criminal case may disclose to defense attorney information obtained through lien. I would also point the court's attention to People v. Cannon, which was decided by Judge Knapp in Third Circuit, which specifically states that lien records are hearsay. They're inadmissible hearsay, So they have to be offered. If AP is not going to offer those records and admit them into evidence, then they're inadmissible hearsay, and the basis for saying whether or not there is insurance on the car is inadmissible.
It was argued that man is not hearsay, it's a machine that's producing this information, therefore cannot be made in statements.
And I can approach, Your Honor, with both the statute as well as the order and opinion by Judge Nash, if you'd like to review it.
Sure. Well, that's happening. Just a clarification, you stated that the vehicle was stopped left the curb.
Yes,
That was after the vehicle left the green light location?
yes.
Okay. This is regarding the council. Right?
Yes.
Okay. I've reviewed this before. It could be looked on this case that he parked on the curb.
I'll let full counsel cross Mr. Fennel on those matters, since they're not related to Mr. Dykes specifically, but I just wanted to object on the record as to inadmissibility. So,
Okay, I've read this, I want to kind of set off a little bit, let's go make sure that. Yeah, it says in section 4, the attorney general or his or her designee, prosecuting attorney or the court in a criminal case may disclose to the defendant or the defendant's attorney of record information pertaining to that defendant that was obtained from law enforcement information system. That's under MCL 28.214. I have not read, I'm not familiar with this case. People see Shawnetta Hannon. I'm not going to
of course,
read through it right now.
of course.
Uh,
I would just have I guess, a standing objection whenever I can take it under advisement and make a ruling on it. And we can continue with the direct examination.
Sure, I will.
Thank you.
Parker, you continue, I have the objection on the record.
And what did you do after you, stopped the vehicle?
I approached on the front right passenger side and observed Mr. Parker sitting in the driver's seat, reaching.
And when you say Mr. Parker, is there somebody present in the courtroom that you came in contact with on that day?
In black shirt, blue mask.
Your Honor, let the record reflect the identification of defendant number 2. You said the defendant was in the driver's seat?
Yes.
Defendant 2 was in the driver's seat? And did you observe anything when you approached the vehicle?
Yes, he then reached back with his right arm and was stuck with something underneath the seat.
And why was that motion significant, if at all?
He said, why was what again?
Why was that motion significant, if at all?
I believe he was trying to conceal some sort of contraband at the time.
Objection, Your Honor, is to speculation. It's the way.
What do you believe you saw?
And what did you do based on that observation?
I had Mr. Speaker step out of the vehicle along with the offender. I advised Officer Perry my observation, and he told me he could see a firearm in plain sight underneath the driver's seat. I told Officer Perry my observation of the tucking underneath the driver's seat, and then he told me he could see a firearm.
I'm objecting about what somebody else said, and he referred to one defendant by name and then said offender. So it's unclear as to who he's talking about. It's kind of a narrative. I object.
Okay. Same objection, Attorney Roberts?
Yes, that's the.
Okay, so you were getting ready to say something that Officer Perry said back to you?
Yes.
Okay, I didn't know if it was one of the defendants saying it back. So I will sustain the objection as far as what Officer Perry said. I didn't hear it anyway.
Acknowledge as to one. Officer Perry said.
Okay, and then just make sure you clarify, either by defendant number 1, 2, or 3, or names. I don't know how you know them.
Understood.
So did you observe Officer Perry recover anything?
Yes.
And what was that?
Firearm from under the driver's seat.
Did you observe Officer Perry recover anything else?
Yes.
And what was that?
A firearm from underneath the passenger seat, front right passenger seat.
And who was sitting in the front of the passenger seat?
Mr. Spivey.
And did you ask the defendants, 2 and 3, if they had a CPL?
Yes, I believe so.
And did they provide a valid CPL?
No, they were all underage.
Was a lien search conducted to determine if they had a valid CPL?
No.
And were the weapons placed into evidence?
Yes, at the 11th precinct.
Do you recall the evidence tag number?
No.
But reviewing your report, refresh your recollection?
Yes.
Objection. I don't know if there's any foundation that he placed anything under evidence, or that he's testifying as to his personal knowledge about whether anything was placed on evidence, considering he just said he doesn't know.
That needs to be clarified. If he knows it's based on everything, how he knows. If that's even.
You know the weapons were placed into evidence?
Yes, I took him to 11th precinct myself.
Yeah. Okay.
Firearm 1, 690092-1.
Well, objection, Your Honor. If we're refreshing, you can't be reading off
To
of
read
the screen.
Let me ask the question.
Well, if I read, I'm probably not going to remember all those numbers by heart.
And in that case,
Memory can be refreshed.
Can we stipulate to be put place on evidence, or is that
We can
a point of
also,
contention?
I can also admit it as evidence before.
Okay. Or however many digits it is, fresh recollection every time.
Do you recall the evidence tag number?
Yes,
And what are those numbers?
690092-1, 2, and 3.
When you say -2 and 3, you're referring to the same first 6 evidence tag numbers? as the
Same
dash?
first 6, yes.
No further questions. Yeah.
Good afternoon, officer. How are you doing?
I'm doing good, so.
Well, thank you.
What's his name?
So before this incident, you had never met Mr. Dykus before.
Gary.
So did you know who he was before this incident?
No,
And you didn't know then whether he was a CDL holder or not before this incident? You didn't know his age before this incident?
no,
You didn't know if he had any criminal history before this incident?
no,
And as you said on direct examination, the first thing you asked Mr. Dykus is whether he has a CDL, correct?
yes,
And Mr. Dykus said yes.
yes,
But after he said yes, you say you get out the squad car,
yes,
and to be clear, you're on the front passenger side of the squad car,
yes,
and your partner, Officer Terry, is in the driver's side.
yes,
You get out on the front passenger side and you say that you approach Mr. Dykus.
yes,
So you walk towards him and ask him the question again,
yes,
and then you say he changes his answer,
yes,
and that's only after you walk out.
yes,
And then you said on direct examination, only after he changes his answer, do you detain him, right?
yes,
And during this encounter, did you say Mr. Dykus was right next to the front passenger side of that gray sedan?
yes,
And you say he turned his right side away from you, away from the squad car.
yes,
And you had to exit the vehicle and walk towards it so you could ask that next question, right?
yes,
You were wearing body camera at the time,
yes, I would,
and the body camera was functional.
yes,
You'd be familiar with that body camera footage if I showed it to you.
yes, I would,
Your Honor, at this time, permission to approach opposing counsel, witness in turn with what will be marked by defense A for identification purposes.
Got it, I'm entering the people to watch this as well, be fine.
No, we know what it is.
Okay.
We've seen that.
Can you see this officer?
yes.
So. Go ahead. For the record, starting at second zero, I'm just gonna play a few seconds. It won't be audio, just let me know if you remember. On to second 33. So officer, is this your body cam?
Yes, it is.
Now playing, starting at second 13. All right, so officer,
You know where you stop.
yes, for the record, stop at second 34. So you did see Mr. Dykus in that video, correct?
Yes,
And Mr. Dykus is not standing next to the front passenger side of the gray sedan. Is he?
not at that time.
The gray sedan is in fact several feet behind him.
At the plate, on that video, yes.
And there's someone already sitting in the front passenger seat at the time.
Yes,
Mr. Dykus isn't next to the front passenger seat of the gray sedan because he's actually next to the squad car.
at the time of the video, yes.
And he's so close to the squad car, he actually has to take a step back when you open up the passenger side of the door.
Yes,
He's so close to the squad car, you can grab him immediately after stepping out of the squad car.
yes,
And you do in fact grab Mr. Dykus.
yes,
And as you heard on the video, after you grab his left wrist, you then ask him whether he has a CPS.
again, yes,
And after you get that first answer, you realize you're not recording the interaction, right?
yes,
So then you press the button and you ask him again whether he has a CPS.
yes.
But you do those only after you've gotten off the squad car, correct?
Do what?
You ask those questions only after you've gotten off the squad car, correct?
Yes,
And you grab Mr. Dykus by his left wrist.
yes,
Now, within seconds of you opening your squad car door, you see Officer Perry get into the shot. He's right next to Mr. Dykus, right?
yes,
And then it's Officer Perry who goes through Mr. Dykus's clothes
that's, yes,
and he recovers the gun.
yes,
And after that happens, you handcuff Mr. Dykus.
yes,
And only after you handcuff Mr. Dykus do you ask for his age.
for the video, yes,
So you agree the video is accurate, right?
yes,
So it's after you handcuff Mr. Dykus that you then ask later on, it's not even in the video right there. It's only after the fact that you ask him what his age is.
that, yes,
And at the time, both you and Officer Perry are armed.
yes.
No further questions, Ron?
Said you ran this vehicle, this Chrysler 300 through Lean, correct?
Yes,
When did you run that through?
I don't recall. It was rambling, I just don't recall when.
Okay. You were at a green light gas station, correct?
Yes,
You've been notified by the department to visit this green light station?
I've been notified by the department.
Yes.
I've done it when I was on the ship, yes, I haven't been notified by anybody to do it.
So you went there of your own initiative, you and your partner, your own initiative?
We were supposed to conduct green light, special attention to the green light locations.
Is there anything that brought you to this particular gas station at this particular time?
No,
And you said that after you got out of the vehicle to conduct this traffic stop, that you observed Mr. Parker lean back, reach backwards in the car?
Yes,
Is there anyone else? Who was in the car that you pulled up?
Mr. Parker, Mr. Spivey, and another minor in the back seat.
Okay, there was someone in the back seat?
Yes,
Who was that?
I'll have to wait for report.
Okay. You don't remember?
No,
Okay. Where was that person sitting?
behind the driver's seat.
Um, no further questions. This time.
Good afternoon.
Good.
Just a couple of questions I'm unclear about. You are sitting in the gas station when you first make observations of this vehicle and the young man in and around it, right?
Yes,
When you first see my client, Mr. Spivey, is he in or out of the vehicle?
out of the view.
He's standing outside of the vehicle?
Yes,
None of your interaction with Mr. Spivey is on your body cam video, is it?
I don't believe so, no.
Mr. Spivey is standing outside of the vehicle?
Yes,
Where? In relation to the vehicle, front, back, side?
so the vehicle we performed a traffic stop on, he was not standing there, he was standing there in a different vehicle.
Okay. When you first see Mr. Spivey, he is standing in the gas station.
Yes,
And he is standing near a vehicle that has nothing to do with anything.
no,
Okay.
Can I clarify, standing in the gas station, like inside the gas station?
in the parking lot.
In the parking lot.
And prior to any interaction with anybody else, you go up to Mr. Spivey and speak with him?
No,
Okay. At some point, do you have some interaction with Mr. Spivey?
yes,
And how does that come to be?
I told him that he couldn't smoke in the parking lot, couldn't smoke marijuana outside public anyway.
Okay, so you see him doing something
Yes,
while he is standing there in the parking lot.
yes,
And is he interacting with somebody else?
yes,
Somebody who's in this vehicle?
yes.
Okay. And do you know how long he's been standing there?
No, they were already there when we pulled in.
Okay, when you pulled in, he was already there.
Yes,
So you see Mr. Spivey and you say something to him.
yes,
And are you outside of your vehicle at this time?
inside,
So you roll up on him so you could speak with him?
yes.
All right. And you speak to him and you say to him, what?
He's not allowed to smoke marijuana.
And in response to you telling him that, what does he do?
He throws it on the ground.
Okay. And do you have any other interaction with Mr. Spivey at that point?
That's when my attention was drawn to Mr. Dennis.
Okay, so you stop your interaction with Mr. Spivey
Yes,
and you turn your attention to somebody else.
yes,
And you in fact get out of the vehicle, have some contact with that person.
yes,
You don't say anything else to Mr. Spivey at that point, do you?
not at that time.
Okay, stop right there, wait right there, young man, I'm gonna come back and write you a ticket. You don't say anything like that to him, do you?
No,
Mr. Spivey, is nearby when he sees you go have interaction with somebody else.
yes.
Do you see what Mr. Spivey does?
He then gets into the front, right passenger side of the,
Okay, and you see that happen,
yes,
and you say, Mr. Spivey, stop, wait, come back. You say anything to Mr. Spivey?
Well, at this time, I'm talking to someone with the fire, so no.
Okay, so the answer is no, you don't say anything to Mr. Spivey.
No.
Okay, Mr. Spivey, in reaction to what you tell him to do, puts out the cigarette and, gets into the car.
Yes.
And does the car then pull off?
Yes.
Does it speed away?
No.
I mean, it, you know, if you've seen the video,
Yes.
it pulls off pretty slowly and, you know, continues on its way. Yes?
Yes.
At some point, after you have detained the individual you were having some contact with, you decide to go after that vehicle, right?
After Mr. Spivey, yes.
I'm sorry,
I would decide to go after Mr. Spivey.
well, and Mr. Spivey's in a vehicle,
Yes.
and you decide to go after that vehicle.
Mhm.
Because at this point, you want to go write him a ticket,
Yes.
a civil infraction ticket.
Mr. Mayor.
And so do you know where that vehicle is going?
Yes.
How is it that you know where that vehicle is going?
When you say where, do you mean like direction or designated place?
I mean, you saw it go in a direction.
Yes.
You didn't pull off immediately after it, right?
No.
Okay. So did you at any point lose sight of that vehicle?
Yes.
But you had some idea of where you could find that vehicle.
Yes.
Was that based on information you got from somebody else?
Was it based off?
I mean, you had some idea of where that vehicle could be found.
I seen where it was going, and also, Mr. Davis said they were going home.
At that point, did you know where home was?
No.
Did somebody give you some information as to where home was?
No.
Home turned out to be how far away from that gas station?
Half a block.
And it pulled in front of a home they had some connection to, right?
Yes, the driver.
And and when you get there, the vehicle had already stopped and parked,
Yes.
and Mr. Spivey was getting out of the vehicle, wasn't he?
He opened the door.
Well, and he was stepping outside of the vehicle,
He was getting ready to step outside.
and you ordered him not to.
Yes.
When you got there, was the door already open?
I believe so, yes.
And he's in the right front passenger seat.
Yes.
And you ordered him to stay put and stay in the vehicle.
Yes.
So after everybody is removed from the vehicle,
He would start over, I'm sorry.
after everyone is removed from the vehicle,
Yes.
did you search the vehicle?
I didn't know.
Did you see a search of the vehicle conducted?
Yes.
When everybody was finally removed from the vehicle, they were removed and detained. They were actually placed in handcuffs.
Yes.
Okay. And the reason you did that was because you thought you saw some movement.
I didn't see him.
Did you see Mr. Spivey make some movement?
I didn't know.
Did you look inside the vehicle at all after these young men were removed from the vehicle?
No, I just didn't buy it as my partner did.
Okay. So did you see where any items were recovered from within that vehicle?
I seen, can I say my partner did?
Did you see your partner do something?
Yes.
What did you see your partner do?
Recover a firearm from the vehicle.
Do you know where it was recovered from? Did you see that where your partner?
Near the front passenger area of the vehicle.
Okay, right front passenger area without, but not, you didn't see where that came from?
No.
Nothing further, thank you.
Other questions? Yes, just one more. Your Honor. This time, the people call Officer Sean Terry. Good afternoon. Could you please restate your name for the record?
Sean Perry?
And are you currently employed?
Yes.
Where are you currently employed?
Detroit Police Department,
And in what capacity?
police officer,
And how long have you been employed as a police officer?
about 3 years.
You're employed as a police officer on January 22nd, 2023.
Yes,
Did you in fact work on that date?
I did.
And did your duties as a police officer take you to an area at or near 19331 West 7 Mile Road, in the city of Detroit, County of Wayne?
Yes,
Did your duties as a police officer also take you to an area at or near 19193 Huntington Road, in the city of Detroit, County of Wayne?
yes.
And what brought you to that first location, West 7 Mile Road?
Providing special attention to the gas station.
And did you observe anything while you were conducting the special attention?
I did.
And what was that?
When I pulled to the gas station parking lot, I observed a vehicle parked at the pumps facing westbound. I observed the vehicle to be occupied by 2 females. And I observed standing at the driver's side was a male, and standing at the passenger side of the door, passenger door was a male. I observed the male standing at the driver door, smoking a marijuana cigarette.
And was the individual who you observed smoking a marijuana cigarette, that individual present in the courtroom today?
Yes,
Did you point out that individual and identify an article of clothing he's wearing?
yes, he's a light skinned male, black t-shirt on,
And also, where he might be sitting?
behind the defense counsel. The one on the end, I'm sorry.
It's 3 black males with
I know,
black shirts on.
sitting next to the lady with the teal jacket on.
Your Honor, may the record reflect identification of defendant number 3? And after making this observation, what did you do?
Like I said, observing smoking a marijuana cigarette. My partner, Officer Flannel, advised me that he couldn't do that, and he threw the cigarette down. I then observed the male standing at the passenger door. Once he observed us, he pinned his body inside the door,
And when you say pinned his body, what do you mean by that?
like his waist area. He was already standing at the door, but he moved his waist in some more after he observed us. And he kind of performed a retention check to his right side of the waistband.
And by retention check, what do you mean?
He touched the right side of his waistband. It's a common act for. He just touched the right side of his waistband.
And in your experience, why would this motion be, what is the significance of this motion, if that is significant?
Objection, Your Honor, to relevance and character evidence. We're not concerned with what this usually entails. We're concerned with specifically what this officer observed. You can't just bring in general suspicions that officers have on particular cases if they need particularized suspicion. He can observe and speak to what he observed. He can't add intentions or possible intentions to actions without foundation being put. This isn't proper foundation, just saying that in his past experience, he has seen this happen. That is inadmissible character evidence.
Mr. Burke?
He is giving particularized observations to seeing specific movements, and then he is testifying to, in his experience, I'm asking why any of these would be significant, if at all.
I don't, the objection for character.
Yes, character, so specifically propensity evidence. So it's being used to suggest that because This officer in the past has observed other individuals engage in this behavior with a specific intention. It shows in this case that it was likely that Mr. Dykes was engaged in the same behavior with similar intentions. In order for him to do that, he needs to speak to specific observations he made at the time. He can't bring in past observations and shoehorn them in as propensity evidence. In the same way that if this officer said, I've seen Mr. Dykes, 2 days ago do this motion, right? That also would be inadmissible. So of course it would be inadmissible for him to say that other people he's never observed before in his life have done these things, and now he's assuming that Mr. Dykes is doing those things for the same reason.
Yeah, I'm going to sustain your objection. Because Officer Perry is speaking to his experience as a police officer. It doesn't change case law. It does not change the elements of the charge here. So whether he believes it to be blading or retention check, the only fact that matters is what actually happened. He can speak, maybe when they ask questions in the beginning, how long has he been an officer? That weight goes to the different things that he's observed as an officer. It doesn't mean that this defendant actually committed that crime, but he's saying as to why it was significant and why he decided to move forward. Does that mean that, well, I just wait till the rest of the test, but I'm gonna sustain.
Sustain or overrule?
I'm sorry, overruled. Thank you. I'm getting 3 black t-shirts, everybody's name getting mixed up, the positions of the cars, I'm overruling it.
So why, if at all, were these motions significant to your statement?
After we observed the retention check, it's consistent for me when someone is concealing a firearm. After he got from the retention check, I looked at the male. He looked pretty young. My partner engaged him, asked him to CPL holders.
Objection, Your Honor, to hearsay.
I heard him.
And acknowledge, Your Honor, it's already on the record. Previous.
It is hearsay.
Yes.
I'm sorry. The male said he was a CPL holder. Scout exited, I exited the vehicle, approached the male. Asked him again, he said he was not a CPL.
Objection, Your Honor, to hearsay. This officer was not the one who asked. I think we already heard testimony who asked. It was not him.
Officer Perry doesn't know that, we've heard it already, it is hearsay, but it shouldn't be already been. The defendant said the same thing. It's hearsay, I'm gonna to sustain.
Yes, acknowledge as to the statements. What did you do after exiting the vehicle?
Engaged the male. Discovered that he was concealing a firearm on the right side of his waistband.
And can you describe where you observed that firearm?
It was on the right side of his waistband, being concealed under his shirt, inside his pants.
And can you describe that firearm?
It's a black firearm. I have to look more report to see what that type of firearm I use.
This is a description of the firearm.
I believe it's a black full-size firearm. I think it was a ghost firearm. It was not a PA. I'm sorry, it's a P90. I'm sorry, P80. So I will have to look at it.
And just to clarify, when you're saying you recovered from an individual, is there an individual in the courtroom today that you recovered this firearm from?
Yes.
Could you point out that individual and identify article of clothing and where he's seated in the courtroom?
Will be sent on the end. Black polo shirt.
And which end would that be?
The opposite end of the other defendant.
The left or right?
My left.
With the record reflect the identification of defendant number 1. And what happened after you recovered these files from defendant number 1?
Yes, as we was speaking to defendant number 1, I observed the male that was standing at the garbage side of the vehicle. Walking away, he got to another vehicle that was parked facing eastbound on the pumps. While I was speaking to defendant number 1, I observed that vehicle drive away.
And is this defendant number 3?
Yes.
And you said you observed that vehicle drive away?
Correct.
And what did you do after that vehicle drove away?
We went to engage the male because we never even finished talking to him. We never got a chance to engage him. He drove away and the vehicle drove into the front of the address group, stated, I think it was 19193, Huntington, and parked left foot of the curb.
What was that last part you said?
He parked in front of the home, just left foot of the curb. He parked the wrong way on the street.
And what did you do after observing this?
I hit my lights to complete my investigation, and I got out the scout car to approach the vehicle. While approaching the vehicle, I observed the driver of the vehicle and the front seat passenger of the vehicle making tucking motions underneath their seat.
And when you say tucking motions, can you describe what you saw?
Yes, I observed the driver of the vehicle reach from the front seat behind his seat to put something underneath his seat.
Objection, Your Honor, to speculation as to what he was trying to do. And then two, lack of foundation. Just can we establish how he is able to see inside the car? So that's objection number two. Number one is the intention. Again, he can say that an individual is reaching. He can't say why that individual is reaching. That goes to the intent.
You saw a weapon, that would be different, so I guess clarification is asked, clarified what he observed.
As to the second objection, I believe it's testified that he was approaching the vehicle when he saw these motions. As to the first, acknowledged for the last portion of tucking something under the seats.
Where you said you saw tucking motions?
Yes,
as you
ma'am.
approached the vehicle?
Yes, man, it was really exaggerated because the driver was reaching behind his seat to put something underneath, he's making a motion behind his seat with his right arm. And I observed the defendant number three, reaching towards the floorboard underneath his seat.
So I'm fine with him saying reaching back, reaching forward, but to say that defendant, the particular defendant who's reaching back is doing that in order to hide something, that goes beyond his personal knowledge. He can't say why the
That's part
reason.
of the statement.
And that acknowledge that. And so, when you say the driver, is there somebody in the courtroom today who you're referring to?
Yes, the male sitting in between the other two defendants.
Your Honor, let the record reflect the identification of defendant number two. And when you said defendant number three was making these tugging motions, where was the defendant number three seated in the vehicle?
The front passenger seat.
And where was the defendant number three reaching when he was making these tugging motions?
Underneath his seat towards the floorboard in front of him.
And in your experience, why would these motions be significant, if at all?
My sense of awareness was heightened because I felt like they was hiding some form of contraband. On approach to the vehicle, I observed both doors open up quickly, and I feared that somebody was going to run. And then when I approached the vehicle, I observed them making them tucking motions, and I immediately engaged them. Everybody in the vehicle put their hands up and stopped moving.
And did you make contact with the individuals in the vehicle?
I did.
Which individual, if any of them, did you make contact with?
The defendant 2 and 3.
And what did you do upon approaching the vehicle?
Like I said, I observed them reaching around, and I was afraid that they were going to run, so I immediately told them to stop moving. I engaged the male, the driver of the vehicle, defendant number 2, who's the CDL holder. He didn't answer me. I detained him in handcuffs due to them being, there's more of them than me, that was me and my partner.
Say that one more time.
I detained the male because there was more of them than us, and I observed them reaching around. I didn't know what they were doing. I detained them. My partner assisted me in detaining the other 2.
So to clarify, you were afraid because you were outnumbered by the occupants?
Correct.
And did you ask all the individuals out of the vehicle?
Yes.
And at this point, did you observe anything?
Yes, after I detained the males, I went back to where I started observing the driver. I'm making that reaching motion.
And was this defendant number 2?
Yes. I observed firearm approach on reapproach of the vehicle from the back seat. I seen the firearm on the floorboard. Plain view.
From where did you see this firearm?
As I walked back up to the vehicle on the driver's side.
Were you outside of the vehicle when you observed this?
Yes.
And was it through a window, through a door?
The door was open.
And so outside the vehicle through the door, are you observed?
Correct.
Can you describe that firearm?
I would have to look right for it. It was a black firearm.
Would reviewing your report refresh your recollection?
I think it was a Ruger SR9 or I need my report.
Yeah, approach, Your Honor. Do you recall what type of firearm you recovered?
Yes,
And what type of firearm was it?
a black Ruger SR9. See,
And what did you do after recovering this firearm?
I recovered that firearm and I bought my partner another weapon recovered. And I checked where I saw the defendant number 3 reach in. That's a firearm that they see as well.
And do you recall what kind of firearm that was under the front passenger?
Yeah, that was a black Glock.
And can you just specifically, just to clarify, where exactly were these firearms recovered?
Exactly where I was observing reaching.
And was this in front of the driver's seat, behind the driver's seat?
So the first firearm I recovered was it was underneath the driver's seat, but like close to behind it. And the second firearm was underneath the passenger seat, like right in the middle.
And the second firearm being recovered, was this within the reach of the driver, that number 2?
Yes,
And the third firearm you recovered, was this within the reach of defendant number 3?
yes.
What did you do after recovering the firearms?
Secured in the scout car, ran all of the defendants for CPL, none of them were CPL workers.
And did you get the age of the defendants?
Yes, I believe 2 of them was 9. I know one of them was 19, the first one engaged was 19. I'm not sure how old the other ones were.
When you said checked for a valid CPL, what did you do to check?
My partner, our boss, he ran them, the lean and talent.
No further questions.
Good afternoon, officer. How are you doing?
Good, how are you?
Well, thank you. It was 1:30 in the morning, right?
Mhm.
So it's dark outside.
Yes,
You said that after you finished detaining Mr. Dykes, that was when you started driving to catch up to the car.
yes,
And you said it was about a block, half a block away.
half block.
Okay. Now, in order to catch up to the car, you had to go somewhat quickly, right?
To get to the vehicle?
Yeah.
Yeah, not too fast, yes.
Well, you went so fast, you kind of flipped over a speed bump, right?
I believe so.
And you said you noticed what was happening on the driver's side and the front passenger side. You could see kind of through the glass. You said you saw people reaching, so I'm just trying to establish. You were driving the car, right?
Correct.
You were what, maybe 3-4 car lengths away when you observed it? How far away were you?
Well, once we got onto Huntington Road, I observed the vehicle, they were driving fast, faster than the speed limit. Well, I observed the vehicle.
Stating that they're driving faster than the speed limit, there's no foundation for that at all that's been established for that commentary.
I don't know what speed limit is. There's no discussion of speeding.
Sorry about that. They were driving and parked left of the curb in front of address on Huntington.
So are you saying it's right when they parked that you observed the reaching motion?
No, Once they parked, I observed the driver and the passenger door open immediately. At that time, I believe I sped up because I was afraid that they were gonna run. I positioned my vehicle behind their vehicle and they shaded my lights. I exited my vehicle, and approached on the driver's side, and at that time, I observed the tunnel motions from outside of their vehicle. Outside, I'm sorry, as I approached the vehicle on foot, I then observed motions.
So they were still in the car at the
Yes.
time, is what you're saying?
Correct.
But you're approaching from the back of the car, right?
Correct.
So there's a driver's seat, correct?
Yes.
And that driver's seat does obstruct the view of what the driver is doing, correct? If you're approaching from the back.
Now that he's reaching to the back, he reached to the back seat from the driver's seat.
I'm just saying, there is a driver's seat, right?
Yes.
And it does obstruct the vision of what the driver is doing. You can't see certain things that the driver is doing.
I couldn't see certain things, but I could see him reaching to the back seat.
And as far as the front passenger side, you're saying, let's establish there is a front passenger seat, correct?
Correct.
And that does obstruct your view of what's happening with the front passenger, right?
Now, I approached the vehicle almost on an angle, you could say, but I watched his whole body lean forward, and I observed him reaching under the seat.
I'm just asking about whether your view is obstructed by the seat. So
To answer your question, no, because when I saw clear as day, everything I mentioned before.
So a seat doesn't prevent you from seeing what's happening.
It could, but it didn't.
How close were you to the car when you were saying you were 13?
After I parked the vehicle, I got out of my car quickly, because I was already afraid they was gonna run, and I walked pretty fast to their vehicle. As I walked up to the vehicle, I began yelling at them to put their hands up, because I was watching them reaching around. So, so I got out the car pretty quick.
So to answer my question, how far away were you from the car when you observed these?
Maybe 5 feet,
5 feet.
maybe less.
And you're saying that you were afraid they were going to run. Did they run?
They did not run.
Did they comply with your instruction?
After I yelled at them, they did, yeah.
Well, I mean, you didn't give them a chance to not do that. You started off yelling. Actually, you said that, right?
I did.
So you didn't start off saying, hey, got a question for you. You said, put your hands up, right?
Yes, I did.
Because as you said, you were scared.
Yeah.
And you were scared because of the reaching.
Yes.
And at that point in time, did you see any firearms, any weapons?
No.
And you kept them in the car, or you took them out?
I detained them from the vehicle.
So you took them out,
Yes.
and you detained them, you said, because you were outnumbered.
Yes, it was just me and my partner, and at that time we had one male detained, and there was three more in the vehicle.
So you detained everyone in the vehicle.
Yes.
Everyone was handcuffed.
Yes.
And what was the name of the other people in the vehicle?
It's in my report. I will have to look at it.
Do you remember the names of those other people in the vehicle?
I'll read my report.
So officer, I'm asking, do you remember the names of those people?
I don't even remember their names. I just need my report.
Well, how many people are in the car who are not present today?
One.
There's one other person.
Yes.
And did you follow up with that person at all?
Huh?
Did you follow up with that person at all?
What do you-
Did you follow up with that person? Did you ask that person whether they had a CPO, whether this was their gun?
I don't believe I know. No.
Even though they were in the car?
I didn't see that person moving around. Yes, I didn't see that person I'm sorry, I didn't see that person making no movements at all as I approached that vehicle. I asked the people I asked the question to because I observed certain things. I observed them making tough emotions. That's why I asked that question.
So to answer my question, you did not ask that unnamed individual who's not in court today whether they had a CPL or whether those were their guns, correct?
I don't believe so, no.
Thank you. Nothing further on.
Nothing on behalf of Mr. Parker.
Attorney Manarino?
first time you see Mr. Spivey, where is he?
It's like, I look right for it,
Okay. I'm sorry. My client,
which is,
which is this young man, third young man.
when I first went to the gas station, I observed him standing at the driver's door of, the vehicle that was parked at the pump space in Westmount.
Okay, so the first time you see him, he is standing outside at the gas station, speaking with, I think you said there's some young ladies in the car,
Correct.
and he's standing outside of the car, speaking with one of the young ladies.
Smoking a marijuana cigarette.
All right, and when you see him smoking that marijuana cigarette, do you say anything to him?
No, he's on my partner's side.
Okay, do you hear your partner say anything to them?
Yes.
In response to whatever your partner said to him, what do you see Mr. Spivey do?
Another cigarette, marijuana cigarette.
Okay, do you, hear your partner say anything to him about detaining him?
Not at that time,
Did you
No.
hear your partner say anything?
No.
Okay, and you have an opportunity to see Mr. Spivey as he's standing outside there smoking that marijuana cigarette.
yes,
To what side of him do you see? The front, the back, the side?
I could only see the top half of him, not even half, the top portion of him, because like I said, he was standing on the outside of the vehicle, which means most of his body was blocked
Okay,
due to the vehicle.
okay. So nothing about him at that point catches your attention, right?
No, I was gonna talk to him, but after we detained the other man for having a firearm on him.
Did you do anything or say anything to Mr. Spivey to let him know that you wanted to talk to him?
He walked away too fast.
You walked away too fast.
Mhm.
Did you tell him, whoa, young man, stop, come back here?
I don't believe so, he's dealing with an armed man, I'm sorry.
Okay. Well, I mean, you didn't do anything that conveyed to Mr. Spivey that he should stop and stay right there so you could further investigate him.
I honestly thought that he was gonna get back in the car with the female, so I didn't know what car he was in, until he drove away.
You see him, leave the area where he is speaking with the female, right? Did you
Also,
see him walk away?
he did walk away.
Okay, he walks away and he walks toward the other vehicle.
While he's walking away, I was dealing with somebody that had a firearm.
Okay, so do you see Mr. Spivey get into the vehicle?
I see him walk away. I think I'm not sure. I think he get into, I saw him get into the passenger side. It happened fast, and then by the time,
You realize this is all on video, right?
yes,
Okay, have you seen that video?
I've seen my video, yes.
Do you, in your opinion, is what Mr. Spivey does is walk away quickly?
He walked away.
He walked away.
Yeah.
Yeah. And he gets into the vehicle, right?
Correct,
And then at some point, the vehicle drives away.
correct.
Nobody, you didn't do anything to stop that vehicle. Hey, stop, we want
Was
to,
I supposed to wave it out?
did you do anything to indicate to these people that you wanted to further investigate them?
I positioned my scarf behind that vehicle, initiated my legs.
Well, they drove away.
I have a block.
Okay, if you don't understand my question, let me know, and I can rephrase it.
Please.
Do you do or say anything to indicate to these young men that they should stop there so you can further investigate them?
I initiated my lights behind the vehicle.
While they are at the gas station, do you
I didn't
do
get a
or?
chance to, man.
So the answer is no, you didn't do anything to stop them from getting in that vehicle and driving away.
That's what you want to hear, I guess.
Well, I want to know what you did. Is that what happened? They got in the car and they drove away
They did try,
because nobody told them to stop, right?
they get a chance to.
Did, after they drive away, you decide you want to do some further investigation.
Correct.
And after they drive away and you decide you want to do some further investigation, exactly what was it that you wanted to investigate them for?
So give them a ticket.
give them a ticket for,
Smoking marijuana in public, man.
so you chased after them to do a further
I did not chase
investigation.
anybody.
You turned your lights up and you sped down the street, right?
To catch up to me, yes.
So, and that was so that you could give
You're demanding a ticket.
a passenger in a vehicle a ticket, right?
Mhm.
Okay. So when you get to that location, the vehicle stopped,
Mhm.
the car doors are open,
Correct.
and you think they're going to get Mr. Spivey, at least is gonna get out of the vehicle and do something.
I was hoping he didn't, but I was prepared for it.
And if he had done that, what crime would he have been committing?
Well, crime would he have been committing?
I'm sorry,
What's your question?
if he had gotten out of that vehicle and walked away, what's wrong with that?
He could have walked. I never said that he couldn't walk. I would have talked to him though. I would have asked him to come here. I would have gave him a ticket.
I don't.
Can you redirect?
No. I have no further questions.
Any from the defense counsel?
None for Mr. Dyke.
Mr. Parker.
And Mr. Attorney Roberts, I did read over this case. And actually, I want to make decisions for argument. It won't change the outcome, which is great for this case. This is from Judge Knapp, 2022 case. The only distinction in this case, which we have witnessed before or had to deal with, is that the officer, in this case, Officer Canada, testified that his partner told him about a lien search or lien release. The court did not address whether or not if Officer Canada searched lien himself, whether that would be hearsay. However, based off of this opinion, it doesn't say that, but it can be understood that it also means that it would be hearsay if an officer testifies to a lien search. As 766.11B1 only allows for certain exceptions, and MCL 766.11B1C would be the only plausible exception, which states that a report other than a law enforcement report that is made or kept in the ordinary course of business. So specifically says any report is allowed other than a law enforcement report, and lien is law enforcement information network. Subsection C says that except for the police investigative report, a report prepared by a law enforcement officer or other public agency. And the public agencies is not an all-inclusive list, but states agencies such as the forensic science, one that produce forensic science reports, laboratory reports, medical reports, reports of arson investigator and autopsy reports. Those to me, what I understand it to be for people who are producing these reports and not a lien network results. So I will sustain your objection for hearsay based off of this case from Judge Knapp as to the lien results after no insurance. So that, Mr. Carter, you want to reserve your argument or go ahead?
No, Your Honor, I'll continue.
Okay.
This time, Your Honor, the people move to find over on count 1 as to the defendant 1, weapons carrying concealed, and as to count 2, weapons carrying concealed as to defendants 2 and 3. we heard from the first witness, Officer Flannel. They approached the gas station. It's a green light location. Giving it special attention when he noticed defendant one, he saw a bulge on his right side. He then exited, and he also observed him wait toward the passenger side of the vehicle, which in the officer's experience is consistent with somebody trying to hide weapon or contraband from the officers. At this point, he asked them based on his age whether he was a CPL holder. At first, he said yes, but then he asked him again, and he said no. He patted him down, and Officer Perry recovered a firearm from the waistband after the officer found a heavy metal object. Defendant number 3, when the officers testified to, they had previously engaged him for smoking a marijuana cigarettes. They asked him to put it out, which he did, prior to being able to give a ticket by the officers. He got into the vehicle and left the scene. Officers were then able to catch up to the vehicle. They put the lights on to initiate a traffic stop based on needing to give defendant number 3 a ticket for smoking marijuana in public. Officer Perry testified that as he approached the vehicle, he noticed both the driver, defendant number 2, and the front passenger, defendant number 3, making tugging motions toward the back seat of toward the back of both the driver and front passenger seat. He also testified that there was another individual in the vehicle, but that he did not observe any sort of tugging motion from this individual. Based on the officers being outnumbered and these tugging motions, all 3 occupants of the vehicle were asked out. They were detained. Officer Perry then reapproached the vehicle, and from outside the vehicle through the open door, he was able to observe a firearm tucked under the driver's seats of the vehicle, where he observed the driver, defendant number 2, making tugging motions forward. Based on this, he then recovered the firearm, placed it on evidence. He then went back to the vehicle and searched where he observed the front seat passenger making similar tugging motions. Once again, he recovered a firearm from underneath the front passenger seat. This item was then placed on evidence. Those defendants were, all 3 defendants were then searched through lean to determine whether they had a valid CPL, not had a valid CPL. People believe that they have had the burden of probable cause to liability.
So I will speak to Mr. Sykes' case, but as a preliminary matter, I think what APA Parker stated at the end needs to be qualified, because based on your ruling, if we're saying that based on the lien results, it's determined that these individuals do not have CPLs, that's inadmissible. So at the very least, that's the defendants 2 and 3. If that's the evidence that they're offering this court, it's not admissible in this court. And I believe I did hear Officer Perry at the very end say he doesn't remember the ages of defendants 2 and 3. If he doesn't remember their ages, then what basis does he have for saying that they are carrying unlawfully? But to go to Mr. Dykes, so the timeline presented by Officer Flannel on cross-examination, I think, clarified what really happened, because you will hear officers often say that individuals are blading their body, doing retention checks, which is jargon for people making common gestures with their bodies, turning their bodies, touching parts of their bodies, which we all do. But specifically, what Officer Flannel said happened on direct examination was not supported by the video. You saw very clearly in the video that the moment Officer Flannel steps out of the vehicle, Mr. Dykes is right there. He's not next to the front passenger side. He's not near that car at all. He's right next to the squad car. He's so close to the squad car he has to take a step back because the door would have hit him as Officer Flannel is coming out. He's so close to the squad car, Your Honor, that Officer Flannel is able to grab his left wrist immediately after stepping out of the squad car. And in terms of the timeline as to when he's getting this yes answer and then these purported no answers, Your Honor, if Mr. Dykes at first says, yes, I have a CPO, that is the end of the reasonable suspicion. If Officer Flannel wants to inquire further, if he wants to ask, okay, how old are you? Can you produce a CPO? Those are questions that he can use to reestablish reasonable suspicion. But if after hearing yes, he decides to get out the car because he doesn't believe Mr. Dykes, grab him by his left wrist, at that point, Mr. Dykes is detained. And insofar as his statement, there's not only a Fourth Amendment issue as to illegal seizure, there's also a Fifth Amendment issue because if you're detaining him, if you have two officers who are fully armed, who are approaching Mr. Dykes, one who is grabbing onto him so he can't get away, he's now detained. And any statements would require some Mirandizing, and there was no indication on either officer's testimony that happened. And I do want to state that, and I can provide this case to Your Honor.
More case law.
It's my favorite thing, Your Honor. So it's People v. Montgomery, which I've discussed before, docket number 21-8174. I think it goes to two things. First, that the timeline is determinative in CCW cases. So just because an officer sees a bulge, just because an officer believes someone is carrying, that's not reasonable suspicion to allow them to detain someone. You need two things: reasonable suspicion that they are carrying and reasonable suspicion that they're carrying unlawfully. Mr. Dykes said yes. The moment Mr. Dykes says yes, again, Officer Flannel is going to have to cure the reasonable suspicion. He's going to have to ask additional questions. And Mr. Dykes does not necessarily need to respond to those questions. And, had he responded to those questions, maybe there would have been reasonable suspicion. But that's not what happened in this case. The timeline in this case is Mr. Dykes says yes. He's grabbed by an officer, an armed officer, and then at which point that officer is saying Mr. Dykes changed his answer. I do want to just mention also in People v. Montgomery, because I think, when the co-counsel gets up and has to talk about these retention checks and these reachings and these grabbings that purportedly happened, specifically in People v. Montgomery, the officer in that case testified that the defendant looked at the officer and then started doing these retention checks and walked away. So I think most officers believe that's enough reasonable suspicion to activate detention. Judge Heisey in People v. Montgomery saying that is not enough, right? You need more than just these allegedly furtive movements, right? You need to establish some basis. And I think both officers testified that they did not initially see any firearms when the car was eventually stopped. I think the second officer, Perry, stated that he was just scared because he thought they might do something, but when he ordered them to do things, he complied, or the other two individuals complied. But I think that, I will let co-counsel speak to those things. And I'll provide this case for Your Honor's reference.
I have it right here.
Okay. But insofar as Mr. Dykes is concerned, the touching, the seizing of him is illegal. Your Honor, if you were a CPL holder, to allow this case to be bound over is to say that an officer, if he doesn't believe you have a CPL, is allowed to grab you and hold you until you answer his question. That's unreasonable under the Fourth Amendment. It's illegal. And for those reasons, we're moving to dismiss on count one for Mr. Dykes. Thank you.
Judge, Mr. Parker. Mr. Parker objects to a bind over in this case
Mr. Parker is the driver of this vehicle that is stopped. Do not believe there is any basis for the police officers to conduct a search of that vehicle. Officer Fleming testified that he watched his partner, defendant Parker, conduct a search of this vehicle after everyone, all three occupants of that vehicle had been secured in handcuffs. There's no danger to the officers at that point. There's no reason to conduct a search of the vehicle at that point. We've heard the prosecutor mention tucking motions, but I believe that Officer Perry was clear that he didn't know if they were reaching for something or what they were doing by moving around. But there's three people in this vehicle. My client is the driver, somebody in the back seat directly behind him. So, I mean, the main thing here, there's no basis to conduct a search of this vehicle at this point. Everybody's secured. No reason to conduct a search. Additionally, I don't think there's enough evidence to connect. There's no evidence to connect my client to that firearm that is found during the search in the backseat. Thank you.
Well, first of all, I will adopt and incorporate and not go over again the arguments of co-counsel. To the extent applicable to Mr. Spivey, I will adopt their arguments. First, I don't see that there has been sufficient proof that Mr. Spivey was in possession of anything. There is in a vehicle that he is a passenger in, something that allegedly is found, and I don't see the probable cause to believe that he was the one who was in possession of that. There are other people in the vehicle, a vehicle that doesn't belong to him, that we don't know if that gun was there before, if somebody else placed it there. There's just insufficient proof that this young man was the one who was in possession of that. And other than that, Judge, I am, is it any wonder that we hear all the time that he looked in my direction and appeared to be nervous? No kidding. That he touched his, he did whatever the term is.
Lady.
That he,
Retention check.
Retention check. Oh my goodness. Make sure I've got my ID on me in case they start harassing me. I mean, I once asked an officer, because they always say, in my experience, when somebody does that, they could be concealing something. And so I asked an officer once, how often? How often when you see this behavior, does it lead to recovery of contraband? And I was surprised by the answer. I think the number I got was maybe 2 out of 10 times they caught a lucky break. I'm asking the court to dismiss this case.
Well,
So the first argument, Your Honor, but once again reiterates that Lean is a machine that cannot provide hearsay statements. Hearsay statements have to come from a human. In any event, all 3 defendants failed to provide a valid CPL, as the officers testified to. what has been cited as by defense counsel as an opinion of the Third Circuit. It is only binding upon that specific defendant. It can only be used as merely persuasive authority in this court. As to the arguments on the Officer Flannel asking about the CPL twice, he did testify that after asking the first time, based on the youthful appearance of defendant number one, he felt the need to ask again, at which point the defendant immediately said no, he did not. The co-defendants in the vehicle.
Wait, Mr. Kirk, are you saying that testimony that he said he did not have a CPL?
Pardon?
You're saying the testimony that he said that defendant one stated immediately did not have a CPL?
Yes, he testified, or he stated, yes, he had one, and then when he was asked the second time, he said, no, he did not have one. And then Officer Flannel felt the need to ask a second time because he saw that the defendant appeared youthful, as he described. And knowing that you need to be over 21 years old to have a valid CPL. As well as seeing a heavy object on the right side of the defendant's body. As to the defendants in the vehicle, I do believe that there was enough for probable cause to search, and that there's a question of fact as to possession of the guns. The Officer Perry testified to when he approached, it was 5 feet away or less, to seeing tucking motions from the front two passengers, but not the back passenger, which is why he didn't ask those further questions to the individual in the back seat. He didn't feel like he saw any sort of motion that suggested that they were hiding something. And so I believe there's a question of fact as to possession of those two guns. And so I would once again ask for this case to be found.
Personal belief. You're saying hearsay has to come from you.
Yes.
Where are you getting that?
Rules of evidence.
So in business document, you're stating comes initially from the email, is what you're saying?
Yes, there are statements made by a human that are put into their reports.
Where does the lane information come from?
Just someone put input in.
From this, and I'm not trying to attack you or make this a big deal, but it's really no problem, and I have this case in front of me. Someone has to put the information to me.
Yes.
I don't expect the person who entered the lien information to testify. But that information, do you agree, is entered by a human being?
Yes.
And secondly, Officer Perry mumbled a lot through the testimony. Did he say that he saw the gun on the floorboard in the passenger behind the driver's seat from outside the car?
Yes, he did. This was on the driver's side.
On the driver's side. Is that what defense counsel, did you all hear that?
I did not hear that. I agree with you, Your Honor, that it was hard to hear at times. I will defer to co-counsel. I didn't hear that.
I did not hear that. My recollection of the testimony was that there was a gun found behind the driver's seat. That I'm not clear whether that was visible or not. I thought it clearly testified that it was under the seat. And the gun under the passenger seat, I do not believe was visible.
Now, I know for the passenger seat, he said it was under the seat in the middle, but I didn't hear that he saw it from plain view, and I thought I would maybe miss that testimony.
I do remember clarifying with him, a line of questioning where I asked, were you outside the vehicle? Was the door open? Did you see it through from outside of the vehicle? As to the firearm underneath the driver's.
Okay. All right, that's all I want. I just had a couple questions. I will start with Mr. Dyke. Attorney Roberts, arguing it. So behind the arguments for defendant 2 and 3 a little bit as well. The issue I have on Mr. Dyke's charge is, as Attorney Roberts stated, the sequence in which the questioning was done. It's hard to ignore the video that was played and it showed the officers. I didn't hear part of it because the audio was not on at that point, but it appears that it was the officer, first officer, Flannel, grabbed Mr. Dykes, and then Mr. Dykes said, no, he did not have a CPO. This is not a question of fact for the trier of fact. Can't alone say that a bulge is enough to have reasonable suspicion. We've gone through this over and over. And the officer stating that they were in an area where a green light is not enough. The whole city of Detroit at this point needs to be under green light. I'm a resident of the city. I feel like there are several, most places are not safe. So the argument that it's in an unsafe neighborhood doesn't work for me. So a bulge alone is not reasonable suspicion. And Third Circuit has also stated that to approach and begin grabbing someone and touching and patting on someone to see if they have a weapon. So for Mr. Dykes, I do not believe that there is sufficient evidence. Also because of the case that Mr. Roberts has brought to my attention just now, where it states here that the court ruled that 36th District Court at the exam that the judge was incorrect by binding over when stating that the law enforcement information network information was not hearsay. It states here that it is. And that the case was remanded based on that. I am in 36th District Court. I cannot tell the Third Circuit Court what he or she could do. I could try, but it probably gets sent back to me. So for Mr. Dykes, I am going to dismiss without prejudice for insufficient evidence based off of the violation of the Fourth Amendment rights. As for Mr. Parker and Mr. Spivey, I have this testimony to me is very confusing. There are pieces missing. I know it's the end of the day, but I don't think that's why. Also, I'm going to rule based off of one, Judge Knapp's decision that lien information needs to be provided, that it's hearsay. So for those two, Officer Terry did not state who was underage. He did not know. So for defendants 2 and 3, based on testimony, we don't know how old they were to be in violation of having a weapon, to conceal weapon. 2, the stop. I understand Officer Perry and Officer Flannel were following up with Mr. Spivey to give him a ticket for smoking a marijuana cigarette at the gas station. However, I am troubled by once again, sequence of events. They're finding guns, but they're just not properly handling cases. And as Attorney Mandarino stated, I only see the cases in which they're successful. So when I see the cases, I'm thinking, wow, if they would just done it right, they would see another gun on the street. But I sometimes forget about all of the times they stop people, pat people down because they had a bulge, a cell phone, their hands in their pocket, and their Fourth Amendment rights are violated, and they are told to just walk away with no recourse. I am not condoning carrying guns without having a license. So I am dismissing your cases off of technicality. So I am dismissing without prejudice or insufficient evidence, but I am not in any way condoning carrying a CPL or carrying a gun without a CPL. So with that, I will sign dismissal and take this.
Thank you.
Thank you.
right. This is case 2355298, people of the state of Michigan versus Soraya Chantel Miller. Ms. Miller is charged with one count of weapons carrying concealed text for preliminary examinations. Appearances.
Good afternoon, Your Honor and staff. APA Jocelyn Patton for the people, PA 3460.
Good afternoon, Your Honor. Good afternoon to your staff, Neighborhood Defender Services by Ken Reagan, P82125, on behalf of Ms. Soraya Miller, who stands behind me to my right.
Ms. Miller, can you state your full name for the record?
Soraya Miller.
Okay. There, both parties ready to proceed.
The people are ready to proceed.
Defense is ready, Your Honor.
Okay, any preliminary matters?
No preliminary matters from the people.
Nothing to defense, Your Honor.
If there's anyone who is on Zoom or on YouTube who may testify on this case, now's your time to log off. With that, time to call your first witness.
The people call Corporal Emmanuel Roberson.
Roll.
Thank you.
Okay, you swear to tell the truth, nothing but the truth.
Yes.
Make sure you speak up in the mic.
Good afternoon. Corporal, could you please restate and spell your name for the record?
My name is Emmanuel Roberson, EMANUELROBERSON.
And are you currently employed? And if so, in what capacity?
Detroit police officer,
And how long have you been employed in that capacity?
7 years.
And are you in any special unit?
No,
Were you employed in that capacity and working on Sunday, January 22nd, 2023 at approximately 11 p.m.?
yes,
And on that day, were you alone or with partner?
with the partner,
What is your partner's name?
Jez Torres Lopez.
And on that day, were you in uniform?
Yes,
What type?
Class B uniform, the uniform I'm wearing right now.
And that has work.
Yes,
And just for the record, can you clarify which level?
has a badge on the front, has my name and badge number on the front as well with the camera, and I have my radio, a duty belt, firearm, flashlight.
Blue or black?
It's in blue. Black boots.
And on that day, were you on foot patrol or in a scout car?
In a scout car,
And was that scout car fully or partially marked?
it was fully, it was partial, it was semi-marked.
Did that scout car have the word police on it anywhere?
Yes,
And did your duties as a police officer take you to 11603 East 7th Mile Road, Detroit, Michigan, in the county of Wayne?
yes.
And what was at that location?
That's just a no-go gas station, which is a green light partner.
And what do you mean by a green light park?
So green lights are, mostly gas stations are green lights in Detroit. It's a business that's monitored 24/7 by the city of Detroit,
And what,
by camera, video camera.
and why were you at that location?
I was at that location, given it special attention. With green light locations, we go in and just monitor the location, make sure there's no crime going on, just, stand by. And, just document that we made the location.
And while you were at that Sunoco, what did you observe?
I observed somebody, armed with a firearm.
And was the, person, the offender a male or female?
It was a female.
And what did you observe? Where was the, offender at when you, recognized them?
As I was entering the, gas station from the front door, I observed, a base plate of a firearm inside of the offender's, right jacket pocket.
And does your training and experience allow you to know while looking at a person's clothing to be able to know if they are carrying or concealing a gun within their clothing?
Yes.
And upon seeing that, upon observing the gun, you observed part of it sticking out and then that's all that you observed in terms of the gun?
The firearm was fully inside of the, pocket, but the pocket was open where I could see the actual base plate inside of the pocket.
Okay. And once you, saw the base plate sticking out, what did you do next?
The base plate was all inside of the pocket. I was just able to observe it through the open pocket. What I did next was I asked if, she had a concealed pistol license.
And how did the offender respond?
She stated that she did not have a concealed pistol license.
If the person that you saw inside of the gas station, where you were able to look inside your pocket and see the base plate, if that person is in court today, could you state where they're sitting in an article of clothing?
They're sitting behind you wearing a black jacket, draped in a beige hoodie.
Let the record show Corporal Robertson has identified Sarah Miller and Sabree Miller as the defendant.
Perfect.
And once you, spoke with, Ms. Miller, what else did you observe? What else was going on at this time?
She was standing at the counter. I observed the firearm. Once she told me she didn't have a CPL, I then recovered the firearm out of her pocket.
And so the weapon was definitely on defendant Miller's person.
Yes.
And the weapon, except for your position where you were standing, you were able to look inside her clothes, her coat pocket, the weapon was for the most part concealed if you hadn't been at that angle.
Yes, it was fully concealed.
And, what type of firearm did you recover?
It was a high point C9.
And did you recover any ammunition?
Yes, when I recovered it, I released the magazine from the firearm. It was loaded with 5 live rounds, and then I removed 1 live round from the chamber with a total of 6 rounds.
And were both the firearm and the ammunition taken into evidence?
As they were taken into evidence at the 9th precinct, and the firearm was not registered to her.
And did you get an evidence tag number?
Yes.
Do you know what that tag number is?
If I can look at my report, I can refresh my memory.
Yes.
I look at it.
Yes. Who's that evidence tag number? Oh.
Okay,
it's gonna be 2201, I'm sorry, 2301220236-1.
And you said she said she did not have a PPO. Did you investigate to determine whether or not she actually did or did not have a PPO?
Yes, I observed in our lien system, our law enforcement information network, I observed that she did have a concealed pistol license.
She did or did not?
She did not.
And she never presented you with,
Correct, she never presented one either.
and what happened after that?
After that, I told her she was under arrest for carrying a concealed weapon. We took her to the Detroit Detention Center.
And did you all ever handcuff her?
Yes.
No further questions with this witness.
Good afternoon, officer.
Afternoon.
Next question. So this was January 22nd, 2022, correct?
2023.
2023. My apologies. It was approximately 11 p.m. at night, correct?
Yes.
It was dark outside.
Yes.
It was cold outside, correct?
I don't recall the exact weather, but it probably was, I'm not sure.
So it would not have been out of ordinary for someone to have a coat on in that weather, correct?
I'm sure.
All right. And you saw my client as you walked into the store, right?
Yes.
Okay. My client was in line making a purchase, correct?
Yes.
She wasn't causing a commotion, correct?
Correct.
And she wasn't doing anything that would have given you notice of her ordinarily, correct?
Oh, yeah. No?
No, she was, or
She was doing something that brought to my attention.
what was she doing?
She was carrying a firearm in her right bucket.
Okay. Now, you wrote a report for this, correct?
Yes.
All right. In your report, you don't describe seeing a bulge, correct?
No.
No, you did, or?
I'm sorry. I don't recall saying I saw a bulge in my report.
What you said was you saw a base plate, right?
Yes.
Describe a base plate.
So the base plate is at the end of the grip of a firearm.
So the butt of the gun?
Yes.
So you saw the butt of the gun, right?
Correct.
And the butt of the gun is flat, correct?
It has a hump on it too. Like, it's a lot of different, it's flat and it has a hump on it as well.
All right. And when you entered the store, you immediately saw this?
Yes.
Now, my client was standing in line, correct?
Correct.
And my client, you were on the right side or the left side of my client?
I was on both sides. I came up behind her.
Okay. But the gun was in her right side, correct?
Yes.
And her right pocket?
Yes.
Completely concealed, correct?
It was deep in the pocket, but I was able to see it.
So you approached my client, correct?
Yes.
And what was the first thing that you said?
Probably said hi. And then I asked her a question.
What was the question?
Do you have a concealed pistol license?
You didn't say what was that in your pocket?
No, I knew what it was.
And at that point, you apprehended her, correct?
When she said she didn't have a CPL, first I recovered the weapon, and then I assisted my partner with handcuffing.
So who took the gun from her? Was it you or was it your partner?
It was me.
Okay. And she was not free to leave, correct?
Correct.
Just a moment.
Right.
No, read the rest.
Appreciate you coming to the mic.
And no further witnesses from the people.
Thank you.
No, Your Honor, thank you.
Mr. Patton? So the officer steps out, you can begin your argument if you have one.
So defendant Sabree Miller is charged with carrying a concealed pistol. First, Ms. Miller did knowingly carry a pistol, specifically a .5.69. Second, Ms. Miller knew that she was carrying a pistol, since it was placed physically in her pocket. It does have weight. Not like you don't notice she's taking the pocket. Third, the pistol was concealed in Ms. Miller, on Ms. Miller's person, since only the base was shown. And was showing from her pocket. If you were standing at the right angle. Complete visibility is not required. So because of this, the people have proved by a probable cause standard the element of the charge of weapons carried in the field, and the people moved to bind over on top of it.
Yeah, we're going to object to bind over, as Officer Roper testified, he saw my client standing in line, making purchase. He did not see a bulge. All he saw was what he described as a base plate or a butt of a gun. The flat smooth surface, to my knowledge, he said he saw a pump. I don't know how that's distinguishable to a person that would be a gun. I don't think he had probable cause to go any further, therefore we object.
Okay, Officer Robertson did testify that he was, at Sunoco, he's 7 miles east of Detroit, green light location. And when he came to the location, he observed the defendant, he said armed with a firearm, and described it as Attorney Riggins, you just stated, saw the base plate in the right side of her pocket, asked if she had a CPL, and she replied no, and then he recovered the gun and arrested the defendant. And then later confirmed through a link search that she did not have a CPL, nor did she ever. So actually, Attorney Riggins, I believe in this case, stronger than if it were just a bulge, because a bulge could be several things. It could be a cell phone, it could be Arizona iced tea, it could be your hand, it could be a lot of things. But in this case, officer did see the end of the base plate that he knew he believed to be a gun. And he was proper in asking, based on his testimony, asking the defendant whether she had a CPL before touching her, detaining her, or seizing her in any way. And she replied no, which then gave Officer Robertson the right to then seize the gun as well as detain the defendant. So I do believe that people have met its burden of proof. And I will have Ms. Miller bound over on that one charge, and her arraignment on the information date will be April 4th at 9:00 a.m. Frank Murphy Hall.